The Supreme Court chamber was a study in solemnity, its marble columns and crimson drapes casting an air of gravitas over the proceedings. The 9 justices sat in their high-backed chairs, their black robes a stark contrast to the polished wood of the bench. Below them, at the podium, stood former Florida Attorney General Pam Bondi, her posture steady despite the weight of the moment. She was representing a coalition of 17 states in a landmark federalism case, Federation of States versus Department of Commerce, a dispute that could redefine the balance of power between the federal government and the states for generations. The case centered on whether recent federal regulations on taxation and land use had unconstitutionally encroached on state sovereignty, a question that had drawn the attention of legal scholars, policymakers, and the public alike. Justice Amy Coney Barrett, known for her incisive intellect and strict textualist approach, leaned forward, her gaze locking onto Bondi. Barrett had earned a reputation as a formidable jurist since her confirmation in October 2020. A former Notre Dame law professor and Seventh Circuit judge, she was celebrated for her rigorous legal scholarship and her ability to distill complex constitutional questions into their core principles. Her presence on the court had solidified its conservative majority, and this case offered a prime opportunity to advance her originalist philosophy. As Bondi began her argument, the room was thick with anticipation, but no one could have predicted the extraordinary confrontation that was about to unfold. The initial exchanges were routine, with Bondi laying out the state's position. The federal regulations, she argued, violated the Constitution by overstepping Congress's enumerated powers and undermining state authority in areas traditionally reserved to them. Her tone was measured, her arguments grounded in practical experience from her time as Florida's Attorney General. But Barrett, ever the meticulous interrogator, was not content with surface-level assertions. She interrupted, her voice cutting through the hushed courtroom with a clarity that demanded attention. "Ms. Bondi," Barrett began, her tone polite but edged with skepticism, "your constitutional argument appears to contradict established precedent in at least 3 major decisions. Have you familiarized yourself with Harrington v. Davis before presenting such theories to this court?" The question was pointed, almost dismissive, and it drew subtle reactions from the other justices. Justice Kavanaugh raised an eyebrow, while Justice Sotomayor leaned slightly forward, her curiosity piqued. Bondi, momentarily frozen, stood at the podium, her hands resting lightly on her notes. For a fleeting moment, the room seemed to hold its breath, waiting to see how she would respond to Barrett's challenge. The case had already generated significant buzz in legal circles. Bondi's selection as lead counsel had raised eyebrows among court observers, many of whom questioned whether her background as a prosecutor and political figure equipped her for the nuanced constitutional litigation demanded by the Supreme Court. Unlike Barrett, whose career was steeped in academic legal theory, Bondi had built her reputation through practical governance and high-profile prosecutions. Her tenure as Florida's Attorney General from 2011 to 2019 had been marked by a tough-on-crime approach and political savvy, but her experience arguing before the Supreme Court was limited. Critics whispered that she was out of her depth, a sentiment that Barrett's questions seemed to echo. But Bondi was not one to be underestimated. Beneath her calm exterior lay months of meticulous preparation, a deep reservoir of legal knowledge, and a determination to prove her skeptics wrong. She adjusted her stance at the podium, her eyes meeting Barrett's with quiet confidence. "Thank you for that question, Justice Barrett," she replied, her voice steady. "I'm quite familiar with Harrington vs. Davis, and if you'll permit me, I'd like to explain why it actually supports, rather than undermines, our position." Barrett's expression shifted subtly, a flicker of intrigue crossing her face. "Please proceed," she said, settling back in her chair. What followed was a legal tour de force that would leave the courtroom and the legal world reeling. Bondi launched into a detailed analysis of Harrington vs. Davis, a case that had addressed the scope of federal authority under the Commerce Clause. "The central holding in Harrington," she began, citing the exact language without glancing at her notes, "relied on a specific reading of the Commerce Clause that Chief Justice Reynolds explicitly limited to circumstances where federal regulatory interests demonstrably outweigh state sovereignty concerns." She paused briefly, letting the weight of her words settle. What's often overlooked is Justice Kavanaugh's controlling concurrence, which established a three-part test for such circumstances. Bondi then applied this test to the facts of the current case with remarkable precision, distinguishing Harrington from the regulations at issue. The regulations in Harrington survived scrutiny because they met all three prongs, particularly the third requirement that federal action be tailored to minimize unnecessary state administrative burdens, she explained. In contrast, the regulations here fail that tailoring requirement, as they impose uniform mandates that disregard the unique fiscal and administrative structures of individual states. Barrett sat up slightly, her interest visibly piqued. Bondi's command of the case law was unexpected, and her ability to weave precedent into a coherent argument was compelling. But Bondi wasn't finished. She seamlessly transitioned to a lesser-known case, Westmoreland versus United States, to bolster her point. This limitation was further clarified in Westmoreland, where the court invalidated federal regulations that failed to meet the tailoring requirement, even while acknowledging legitimate federal interests, she said. Justice Sotomayor interjected, her tone probing. "Counsel, Westmoreland was a 10th Circuit decision, not Supreme Court precedent. How do you justify relying on it here?" Bondi didn't hesitate. "That's correct, Justice Sotomayor," she replied, but this court cited Westmoreland's reasoning approvingly in footnote 23 of Montgomery versus Louisiana, specifically when discussing the limits of federal regulatory authority in areas of traditional state prerogative. The courtroom stirred slightly as several justices flipped through their case materials to verify her assertion. Barrett's expression shifted from skepticism to something closer to reassessment. Bondi pressed her advantage, addressing Barrett's earlier concern about Article 3 jurisdiction. "I'd like to direct the court's attention to an often overlooked passage in Justice Scalia's dissent in Williamson County," she said. While his opinion didn't carry the day, his analysis of jurisdictional limits in federalism cases was subsequently adopted by this court in Nick versus Township of Scott, effectively overruling the majority position in Williamson County. Barrett leaned forward, her curiosity now unmistakable. "Are you suggesting that Nick's holding on property rights extends to the broader federalism context we're addressing today?" she asked. Yes, Justice Barrett, but not through simple analogy, Bondi replied. She proceeded to outline a sophisticated legal theory, connecting Nick's reasoning to the current case through a series of lower court decisions that had gradually expanded its application. Her analysis was meticulous, weaving together precedent, statutory interpretation, and constitutional principles with a clarity that captivated the room. Justices Thomas and Kagan, typically reserved during oral arguments, began posing follow-up questions, which Bondi addressed with equal precision. The dynamic in the courtroom had shifted dramatically. What had begun as Barrett's attempt to expose weaknesses in Bondi's reasoning had evolved into a high-level constitutional dialogue between two formidable legal minds. When Justice Alito raised a potential conflict with the court's recent ruling in Texas versus Johnson, Bondi distinguished the cases on grounds so specific that several justices could be seen checking their notes. Her recall was impeccable, her arguments unassailable. Barrett, now fully engaged, posed a new challenge. "Ms. Bondi," she said, her tone no longer dismissive, but genuinely inquisitive, "your reading of these precedents is certainly creative. However, I'm concerned that accepting your interpretation would require us to significantly narrow our holding in Denison, which has stood for nearly a decade as a framework for federal-state regulatory boundaries." The question was complex, designed to test the limits of Bondi's legal theory. The courtroom tensed, anticipating her response. Bondi paused briefly, gathering her thoughts. "Justice Barrett, I have tremendous respect for the Denison framework," she began. "However, I would suggest that applying Denison to the current facts doesn't require narrowing its holding, but rather recognizing its inherent limitations, limitations that Justice Gorsuch himself acknowledged when writing for the majority." She then quoted directly from Gorsuch's opinion. "This framework establishes general principles for typical assertions of federal regulatory authority while recognizing that unique circumstances may necessitate more nuanced analysis." Bondi's next move was her most compelling yet. "Our case presents precisely the kind of unique circumstance Justice Gorsuch anticipated," she argued, "where federal regulations technically comply with Denison's formal requirements while functionally eliminating state discretion in a manner the framework never intended to permit." The argument was bold but meticulously reasoned, and it resonated with the justices. Even Barrett, who had begun the session intent on challenging Bondi, appeared to be reconsidering her initial assumptions. As Bondi's time neared its end, Barrett posed a final question, a hypothetical scenario involving conflicting state and federal interests so intricate that it would later be incorporated into constitutional law exams. The room collectively held its breath, assuming the complexity would finally expose Bondi's limits. Instead, Bondi responded with a performance that would become legendary in legal circles. "That's an excellent hypothetical, Justice Barrett," she said, her voice steady. "It highlights precisely the constitutional tension at the heart of our case." Rather than offering a simplistic answer, Bondi deconstructed the hypothetical, identifying three distinct constitutional principles that would guide the analysis. She cited relevant precedents for each, including several authored by Barrett herself during her time on the Seventh Circuit. "In your 2018 opinion, in Wisconsin Manufacturing Association v. EPA," Bondi noted, You wrote that when regulatory frameworks create irreconcilable obligations, courts must examine which sovereign possesses primary constitutional authority over the specific subject matter. That reasoning provides a valuable roadmap for your hypothetical. Barrett's expression betrayed genuine surprise, not only at Bondi's familiarity with her lower court decisions, but at the sophisticated application of her own judicial philosophy. The courtroom buzzed with whispers as observers realized they were witnessing a pivotal moment. Bondi continued, drawing on a concurrence by Justice Thomas in Department of Revenue versus McClintock to further refine her analysis. Her response was so precise that several justices began taking detailed notes. Justice Kagan, known for her incisive questioning, attempted to probe a potential weakness. Ms. Bondi, your application of Justice Thomas's McClintock concurrence seems to overlook the subsequent limitations established in Freridman. How do you reconcile those positions? Bondi was unfazed. Justice Kagan, Freridman's limitations specifically addressed interstate commerce applications, not the core federalism principles at issue here, she replied. In fact, the majority in Freridman explicitly stated that its holding does not extend to cases where federal regulations effectively commandeer state administrative apparatus under the guise of regulatory coordination, which is precisely our argument today. Kagan nodded slightly, visibly impressed. Bondi's ability to navigate the court's complex jurisprudence was undeniable. She went on to trace the evolution of federalism doctrine through decades of decisions, identifying subtle shifts that many scholars had overlooked. Barrett, now treating Bondi as an intellectual equal, posed a follow-up question that invited her to shape constitutional doctrine. Ms. Bondi, if we were to accept your framework, how would you suggest we articulate the limiting principle to prevent its misapplication in future cases? The question was a remarkable acknowledgement of Bondi's legal acumen, and she rose to the occasion. Justice Barrett, I would propose a three-part standard, she said, outlining a nuanced framework that balanced state sovereignty with legitimate federal interests. The standard was so thorough that it addressed potential objections before they could be raised, earning nods of approval from several justices. When the Chief Justice announced that Bondi's time had expired, an unprecedented moment occurred. Barrett requested that she be granted additional time to complete her analysis. It was a rare procedural courtesy, signaling the court's deep engagement with her arguments. As Bondi concluded, the gallery erupted in whispered assessments. Constitutional scholars exchanged glances of amazement, while the Solicitor General, representing the federal government, hastily revised his remarks, recognizing the formidable challenge Bondi had posed. The impact of Bondi's performance reverberated far beyond the courtroom. Legal blogs and forums dissected every aspect of the exchange, with SCOTUS blog publishing a rare mid-argument analysis titled Bondi's Tour de Force Reshapes Federalism Debate. Constitutional law professors across the ideological spectrum praised her mastery of precedent and theory, with one tweeting, Bondi's command of federalism jurisprudence was nothing short of masterful. This will be taught in law schools for years. In the court's private deliberations, Barrett reportedly acknowledged her initial misjudgment. We witnessed an extraordinary display of constitutional advocacy today, she told her colleagues. Ms. Bondi's analysis requires serious consideration, particularly her framework for balancing state and federal interests. The case, initially expected to favor the federal government, became far more competitive, with justices grappling with Bondi's meticulously constructed theory. When the court's opinion was issued 3 months later, the states prevailed in a 6-3 decision. The majority opinion, authored by Justice Gorsuch, adopted significant portions of Bondi's proposed framework, citing her oral arguments directly, an unusual acknowledgement of an advocate's influence. Barrett wrote a concurring opinion that engaged with Bondi's analysis of her own prior decisions, praising its persuasive application. The decision established a new 3-part test for evaluating federal regulations impacting state functions, dubbed the Bondi Test by legal scholars. The Barrett-Bondi exchange entered legal law as a testament to the power of intellectual humility and rigorous advocacy. Law schools began using recordings of the argument in advocacy courses, highlighting Bondi's preparation and Barrett's willingness to reconsider her assumptions. 6 months later, at a Federalist Society event, the two appeared together, discussing federalism jurisprudence with mutual respect. Barrett remarked, "The most valuable moments in constitutional development come when our assumptions are challenged by advocates who approach legal problems from different perspectives." Bondi responded, "The strength of our legal system lies in the rigorous testing of ideas, regardless of their source." The encounter underscored a fundamental truth. The most significant legal advances often emerge from the thoughtful reconsideration of preconceptions. In legal circles, pulling a Bondi became shorthand for an underestimated advocate revealing unexpected brilliance, while Barrett's intellectual integrity enhanced her reputation as a jurist open to persuasive reasoning. Their exchange not only shaped constitutional law, but also served as a powerful reminder that in the pursuit of justice, brilliance can emerge from the most unexpected sources.